Good afternoon. I'm here today to help you build an estate plan. Some of you may be attending this webinar because you don't have an estate plan or don't even know what it means to have one. Some of you may have executed documents years ago and are probably thinking, do I need to update them? Or some of you may have had a major life event, a marriage, birth of a child, a divorce, even a death, and need to update your estate planning documents. So today I'm going to walk you through that process of how you craft these documents. I want to introduce Princess Ruff, who's kind of helping me moderate this webinar. And so if you have any questions during this time period, Princess, will you let them know how they need to submit questions?
Yes, so if you have any questions during Stacey's presentation, you can just click at the bottom of your screen where it says Q&A and drop your questions in there, and then we'll answer them at the end.
Yeah, that'd be great. So before we get started on crafting your estate plan, I kind of want to share with you why this is so important to me that I want women participating in this process. Today is the 5-year anniversary of my dad's death. Although it's almost been 5 years, I can distinctly remember my mom on the phone with our family's life insurance agent a few days after he died and her asking, do I have any money? She honestly didn't know. And my mom's not an aberration. In my legal practice, I am seeing that women are not participating in the financial and estate planning process until they get crushed by some unexpected life event. This isn't just women in my mom's generation, it's my generation and even younger generations. So my personal mission is to change that. My dad's death and helping my mom with the aftermath transformed me. I saw firsthand the complexities of the estate planning and administration process for family businesses, and especially for women. In the years since, I have found a healing process that gives meaning to my own life and offers me an opportunity to use what I have learned to help others navigate this process. So in honor of my dad was always the person you went to when you did not know what to do or had nowhere else to go. He was a backstop. He was my backstop. So I now honor my dad's legacy by being a backstop for my family, my friends, and my clients. So I want all of you to know that, yes, anytime you need something, I can be a backstop for you. So why do you need to participate in this process? At some point in your life, you are going to be the primary decision maker, whether you decide to never get married or you experience one of the situations where these hard facts, where 80% of men die married, 80% of women die single. Widows outlive their husband by an average of 14 years. The average caregiver of an elderly person is a 49-year-old working woman, and 50% of marriages end in divorce. So it is imperative that you learn to participate in this process. And today I'm going to show you how. So the first part of the process is to sort of assemble your estate planning team. And this is sort of a team of trusted advisors. And who is on this team? Typically you have a CPA, a financial advisor, a trust and estate lawyer, and a life insurance agent. If you don't have all of these, some of you may have one. Like you've got the guy who does your annual income tax return. You might have had some agent that sold you life insurance years ago. So it's important to kind of assemble all these people together. If you don't have one of these advisors, you can ask for referrals. Ask your CPA for a lawyer. Ask your lawyer for a CPA. I tend to get a lot of calls always asking for CPAs. And it's important to kind of know what questions to ask these advisors. Your advisor should be an advisor. You should not feel stupid asking questions. You should understand what their fees are. There shouldn't be any surprises. These are the people that they have your best interests at heart, and you should trust them and be able to have a relationship with them. So now that you've sort of assembled this team, now what? So let's say you've come to me and you've chosen me as your estate planning lawyer. Typically, we're going to have some sort of introductory call. You're going to call me and we're going to just sort of shoot the breeze. I'm going to kind of understand what's going on in your life. Either before this call or shortly thereafter, I'm probably going to send you an estate planning questionnaire to ask you to fill out. One page of this questionnaire is what we call an asset inventory. I need to know what you own, how it's titled, what the value is. I need this because I need to know what assets you have so I can plan for how they're going to pass at your death. And like in other words, I need to see the big picture. So if you're asking yourself, where do I get information on my investment accounts or my property or how it's titled? Typically, you do need to go to your CPA and your financial advisor and your life insurance agent. So these folks should be able to help you assemble this information. And then once you give it to me and I understand your assets, see the whole picture, we can sort of start designing your estate planning documents. There are some estate planning documents that every individual needs, regardless of their age, their marital status, or their wealth circumstances. And these documents are a will, a general power of attorney, and advanced healthcare directive. And I'm going to talk about beneficiary designations in a moment. So for those that don't know, a will is a legal declaration in writing of your intention regarding the property that you own at your death. I know that sounds kind of wordy, but basically your will is kind of saying, okay, I want my property to go to these people under these conditions, these circumstances. A will may also include the appointment of a guardian for minor children. These are basically the substitute parents if something happened to you and your spouse. Wills may also be structured to give specific property or money to certain people. You know, I want to give $1,000 to each of my grandchildren. I want to give $10,000 to the American Cancer Society. You can make these type of bequests in your will. Then typically once you make these bequests, you might say, okay, what is left in my estate after I've made all these other bequests, whatever's left over goes to my spouse, or goes, if my spouse isn't living, it goes to my children, either in trust or just outright in equal shares. In your will, you will also need to appoint an executor. And this is a fairly important role. It's a short-lived role, but it can be pretty tedious. The executor's responsibilities include basically gathering all the assets of your estate, determining what your debts are, and then distributing those assets pursuant to the term of the will. There's also some ancillary responsibilities where the executor may need to file income tax returns to the estate, file your last personal income tax return, and if you had a large enough estate, you might have to file an estate tax return. So you're like, well, who is somebody who should be an executor? It's somebody who's sort of a taskmaster. They're technical, administrative in nature, and it needs to be someone who has the time, experience, and inclination to do it. I typically do not recommend having the surviving spouse be the executor, because the surviving spouse is grieving and the business side of death can be overwhelming. I like to see provisions in wills where the surviving spouse can appoint maybe a co-executor or successor executor if the task is just too much to deal with. And I'm going to talk a little bit more about wills and structuring that in a minute, but I want to jump to sort of the next document that's extremely important, and that is a power of attorney. A power of attorney, under a power of attorney, you can designate someone to act in your name and basically over your property. They virtually exercise all rights of property you own. I like to say they can manage the business side of your life if you should become incapacitated. They could sell your house. They could transfer money. They can execute legal documents in your name. But it's very important to understand that the power of attorney, one, does not stop you from doing acts. Like I can appoint my sister as my agent, but I could still also do those acts. So this is not helpful if for some reason when an elderly person starts suffering from dementia, the power of attorney does not stop that person from still, writing checks or doing things. The power of attorney also terminates at your death. So upon your death, someone cannot walk in with a power of attorney and deposit money, transfer money out of your bank accounts. The other document that is crucial to have, and I know COVID-19 has sort of brought this even more to the forefront, is an advanced directive of healthcare. And that's what we call that document in Georgia. Under an advanced directive for healthcare, you delegate someone of your choice the power to exercise virtually all of your rights. You have to accept or reject medical care. So if you are incapable of indicating your intent, your physician may rely on the power holder to make all medical decisions for you, which includes the power to continue or terminate life support systems. And kind of what I want to, final thing to think about, and this isn't a document that I would craft, but I ask my clients to look at their beneficiary designations, because property which passes under the terms of your will does not include assets which you jointly own with right of survivorship, like you might own the house with your spouse jointly, or assets that pass by beneficiary designation. This is retirement accounts and life insurance or any sort of TOD, transfer on death, or POD accounts. So it is essential that you coordinate the title of your real estate and your beneficiary designations with the terms of your will. I tend to get, in our last webinar, I kind of get questions about trusts. Kind of, do I need to create a trust? What is a trust? So I like to think of a trust as sort of this like protective envelope. You, as the grantor, you basically decide what to put in that envelope, and you sort of designate someone called the trustee to be the holder of the envelope. And you give directions to the trustee on when the envelope can be opened and the assets can be taken out and distributed to people you have named. But until these conditions are met, these assets stay in this envelope. And the trustee gig is a long-term gig. Someone you appoint as trustee has got to be someone diligent, trustworthy, willing to look out for the best interests of those you have named the beneficiaries. And that's typically your children. So you can create trusts during your lifetime, or you can create them by the terms of your will. So you might have heard the term living inter vivos trust. These are, again, trusts that are created during your lifetime. You might create a revocable trust under certain conditions. A revocable trust is something that you can revoke at any time. And you're kind of like, well, why do I want to do that? You might create a revocable trust if you were worried about incapacity issues. Like you were literally worried about yourself getting taken advantage of elderly. You see this a lot of you're worried about your parents suffering from dementia and like getting taken advantage of, writing a $10,000 check to some bogus charity that someone or someone's trying to date them and wanting them to pay for a bunch of off their debts. So you're worried about, you want a trustee to sort of control what the settlor or the grantor of the trust is doing. Or you might create a revocable trust if you're in Georgia and you own property outside the state of Georgia. For example, you own a beach house in Florida. Florida probate is fairly expensive and time consuming. So you may want to, if you've already had the property in a trust, then you don't have to worry about probating it in Florida upon your death. And the other reason you may want to have a revocable trust is if you want to disinherit heirs or you don't know where to find them. Because if not, if you can't track down heirs or you want to disinherit, then that can make probating of the will time consuming and expensive. So the other type of living other trust that may be created during your lifetime is an irrevocable trust. And this is kind of beyond the scope of this webinar, but if you have a substantial estate and want to avoid estate taxes at your death, or you are concerned about creditor protection issues, then an irrevocable living trust may be something you want to consider. The other time a trust gets created is a testamentary trust. And this is kind of where, most kind of see that. You want to do this when, you're concerned about assets for your minor children. If something happened to you or happened to you and your spouse, you would want those assets to go into trust until your children possibly reach a certain age or they stay a lifetime. Or you might create a trust under your will. You don't want your kids ever having free access to this money. You're worried about, their inheritance could be subject to a bad divorce, bad business decisions, unfriendly creditors. Or you may just want to make sure your assets are used for a very singular purpose. You may just feel strongly that this money can only be used for education of any future generation. And you want this trust to be created upon your death. So the trust terms are basically embedded in the will. That's where the trust gets created. So here's kind of an example, and this is kind of hard to read, and I apologize for that. I was sort of submitting this form from my estate planning questionnaire. So this kind of, this is sort of basic, and during our questionnaire, you would sort of ask these questions when you were structuring your wills or any trust we created. You kind of see the questions there. We ask for specific bequests. I want my diamond ring to go to my daughter, Liza, because I don't want my sons, Colin and Miles, marrying some girl that ends up with my ring. You may want to have a spot where you feel strongly about certain charities, that you want to make sure that certain gifts are made upon your death. And then the remainder of this of the estate, this is for a married couple, will say, outright to my surviving spouse, or in trust for your surviving spouse. There's reasons to do that. Some are estate tax planning. Some may be that you're concerned that, if something happened to you and your spouse remarried, you wouldn't want those assets somehow ending up with the new spouse. And then we say, okay, upon both of your death, do you want everything just to go outright to your children if they're already adults? Would you want to hold it in trust till your child reaches certain ages? And then finally, you kind of have to determine if something happened to all of you, who is the ultimate beneficiary? The property has to end up somewhere. A lot of times the default is it goes to your heirs at law. It just goes to Georgia law, who starts out with your parents. After your spouse and sibling, of your spouse and children, it goes parents, siblings, niece and nephews. It kind of just goes down a tree till it finds an heir. So if you feel strongly about certain people who should end up with my estate, if something happened to you or your spouse and your children, you would need to designate that. So obviously COVID-19 has brought to light, I'm going to go back one second. Once these documents are drafted, reviewed, and approved by you, you now need to execute them. Georgia law has very specific laws about how it needs to be executed. Your will has to be executed in front of 2 unrelated witnesses and requires a notary to also attest to watching you sign and the witnesses sign. Your power of attorney also requires 2 unrelated witnesses and a notary. And your healthcare directive requires 2 unrelated witnesses. So the signing process is a formal process, an intimate process. And typically in normal times, we would execute these in our office. Given COVID-19, we've had to sort of, revise this on the fly. So now we kind of give our clients 2 options and they can determine what they're comfortable with. One is to do sort of the drive-through will signing in our parking lot where the witnesses stand with masks on, more than 6 feet apart. There's a fold-out table set up, a bunch of hand sanitizer, your own pens, and you sign. And we kind of do that. The other is a virtual process under Governor Kemp's emergency order, but there's some kind of issues with that with the virtual signings that it's basically said that we would have to come back and execute them the normal way when it's all over. So at first I had clients wanting to do the virtual signings, but it seems lately, because I guess they feel like it's not any less safe than going to the grocery store, they've been doing sort of the in our parking lot will signings. But the point is that we are still doing these documents and executing them because people are concerned about it. I just want to talk about a practical thing that happens. Okay, you execute all these documents and COVID-19 has brought to light that, people are worried about incapacity. You're worried about my parents ending up on a ventilator, like what happens? So in addition to executing powers of attorney, healthcare directives, or revocable trust, there's also some practical things you need to do. One is you need to make sure your agents know that they're your agents. Don't just execute the documents and never tell anybody that, hey, you're my agent. And give your agents copies of these powers of attorney and healthcare directives. Give your agents electronic passwords. Everybody has online banking now. No one's going to a bank and just saying, hey, I've got a power of attorney, let me in and do what I know. Most likely it's an online banking password protected account that someone needs to know how to get in and access. Provide your agents with the name of your doctors, your financial advisors, your lawyers, who do they need to contact to figure out what's going on in your life. Let your agents know where you keep other essential documents. And finally, let them know how to get in your house. God forbid you have a pet or they need to retrieve items for you. Let them, give them this information. So now that you've sort of, for those who had estate planning documents executed, my last webinar, I got a question, how often should I update my estate plan? The kind of simple answer is when laws change or lives change. In the past 5 years, we've had substantial changes in the law in the tax and estate planning world. So you definitely want to make sure that your estate planning documents are taking advantage of current tax laws. The other issue is lives change. Obviously there's major life events. There's when, a divorce, a death of a spouse, there's other things, but there may be things that are less obvious. For example, you may be like me and my husband, Jim. When our first son, Colin, was born, we executed wills and bought term life insurance and threw the wills in the drawer or safe or whatever we have them in. And outside of just, making payments on our annual life insurance premiums, didn't think much about our wills. So all of a sudden we've, flash forward, 17 years, Colin will be 18 in July. And lo and behold, these wills have, mandatory distributions that Colin would receive everything at age 25. And while I had high hopes for Colin at age, 1, that he would be somebody who could handle an inheritance at age 25, I deal in the reality of 17-year-old Colin, and that doesn't seem like such a good idea. Also, if you're kind of like my mom, who told me at one time that now I know why I had kids was to have grandkids, she wants to make sure that I don't blow all the inheritance and there's some left over for my kids. So the kind of bottom line is, if you haven't thought about your estate planning documents in a while, and that's perfectly natural because most people don't wake up and say, wow, this would be a great day to call my lawyer and talk about my death. You want to make sure that these documents are taking advantage of current tax laws, are based on your current life circumstance, and that they are fulfilling your objectives. So now what I want to do is kind of put all this into practice. We're going to kind of look at some case studies. And while every person's situation is unique, you might identify with some of these women I'm going to talk about. I do want to kind of put a caveat. These are fictional clients. I made this up. This isn't based on any one person. And I'm just highlighting certain planning techniques. So this is by no means comprehensive legal advice or comprehensive estate plan. I just kind of want to let you see how this sort of all plays out. So let's meet our first woman. Let's meet Caitlin. Caitlin is a millennial who graduated from Georgia Tech. She landed a really cool job as a software developer in a local Atlanta-based company. She rents a loft apartment on the trendy West Side. While Caitlin doesn't have a spouse or kids to worry about, has not yet amassed a fortune, Caitlin could benefit kind of from the following. A simple thing for Caitlin to do is to protect her financial assets without complex planning through her beneficiary designations, such as she could look at her 401k accounts, her health savings accounts, any other investment accounts or life insurance policies she may have with her company. So as I said earlier, accounts with beneficiary designations, unlike other assets, pass pursuant to the terms of those designations and not pursuant to the terms of your will. As I said earlier, it's important to review them to make sure they are up to date. And doing this is an easy way for Caitlin to ensure that her assets go where she wants them to go upon her death. Since Caitlin does own a car and has some personal property, I would also advise her to execute a simple will, a power of attorney, and a healthcare directive. Since Caitlin's parents are in their 50s and she has a good relationship with them, I would advise her to name her parents as her agents. So let's look at our next client. Let's meet Lucy. Lucy is 45 and single. She's an executive at a healthcare company. She loves exercise at Blast, loves to play Sunday out to tennis with her tennis team. Lucy loves her 2 golden doodles, and she loves her sister's children, her nieces and nephews. Lucy may get married one day, but she probably doesn't really want to have kids or adopt them for now. Lucy owns her own home in Peachtree Park. She has significant assets in her company's 401k. She has separate savings and checking accounts. So I would advise Lucy to create a pet trust in her will if she's concerned about who's going to take care of those golden doodles if something happened to her. With these sort of pet trusts, you kind of put in a monetary amount, let's say $10,000 for these, so whoever gets these dogs can sort of take care of them and take up their grooming and vet bills. If Lucy does not have any estate planning documents, then the default is that everything goes to her parents. Those would be the first line of heirs. So if she wanted to provide for her nieces and nephews, then we could make that provision in her will. We could create a trust for them if they are minors. We could also, if she wanted to be able to pay for their college, we could do things with a trust that went into paid for 529 or to make sure the trust was used for education. Since Lucy's parents are in the late 70s, I would advise her to name her older sister as her agent under her power of attorney and healthcare directives. Okay, let's meet Allison. Allison is a 55 divorcee. She lives in Brookwood Hills, and she got a pretty substantial amount of assets in her divorce. She has 2 kids in college and 1 still in high school. She works part-time in a local boutique. Allison's not getting serious with Tim, and she may want to consider another marriage. Tim also has kids of his own. First of all, if Allison hasn't updated her estate planning document since her divorce, she needs to do that immediately, as her ex-husband is probably the primary agent of her power of attorney and advanced healthcare directive, and she probably doesn't want him making those decisions for her. She also needs to make sure her college kids have executed powers of attorney and advanced healthcare directives, naming her as an agent. Once your kids are over the age of 18, they are considered adults, and they don't have to involve you in their financial affairs or healthcare decisions. And God forbid one of Allison's kids ends up in St. Mary's Hospital in Athens, Georgia with alcohol poisoning, she needs to be able to make sure that she can speak to her kids' doctors, understand the health bills, and understand what's going on with her kid. I think she also probably needs to have a power of attorney, get access to her kids' academic records in Georgia. And I think some people always ask, well, what if my kid won't sign it? Well, presumably you still control some sort of purse strings for your child, and I would make sure that money was conditioned upon executing these documents. Additionally, if Allison wants to get married to Tim down the road, before they get married, I would advise them to consult each with their own lawyer and how they should merge or keep their assets separate so that their assets go to their respective kids upon their deaths. And this is kind of a mess if it's done after the marriage. All right, now let's meet Sally. Sally's been married to Jim for 18 years. They live in a swim and tennis neighborhood in East Cobb. Jim works for Cox Communications. Jim inherited a substantial amount of money from his parents, and Jim and Sally have accumulated substantial wealth. They last executed their will 16 years ago when their first son Connor was born. They now have 3 boys, ages 16, 13, and 11. Their original wills had trusts for their kids with a mandatory distribution age of 25. Sally's not concerned about her boys are receiving such a large inheritance at an early age. They also had named Sally's parents as guardians, and Sally's parents are now in their early 80s, and Sally thinks it'd be a huge burden for her parents to raise 3 teenage boys if something happened to them. Sorry. Also, Jim and Sally are both concerned that if something happened to one of them and they got remarried, they would not want the new spouse to be able to inherit assets that they think should go to their kids. So I would suggest at this juncture that Sally and Jim, under their wills, create trust, that any assets from the death of the first spouse goes into trust for the surviving spouse and the kids. Upon the surviving spouse's death, the assets remain in trust for the kids for their lifetime or a much later age, if that's what they're comfortable with. I would also advise them to change the guardians to maybe siblings or godparents or family friends that would be able to take on the responsibility of 3 teenage boys. And our last client we're going to meet today is Carol. Carol's husband Bob died 2 years ago, and Carol's adjusting to life as a widow. She's an active golfer and loves to play bridge at that bridge center in the Fountain Oaks Shopping Center. Carol has a condo in Buckhead, but she's also bought a place in Highlands, North Carolina to get out of the hot Atlanta summers. Carol is concerned about incapacity because her mother suffered from dementia in her 80s. So at this point, I would advise Carol to execute a revocable trust and place her Atlanta condo, her Highlands home, and any investments, bank accounts into that revocable trust. Carol can be her own trustee for now, while she's capable and wanting to do that. But upon any signs of dementia, her 2 daughters can become the successor co-trustees. So they can manage Carol's affairs for her, but also make sure she doesn't get taken advantage of. So I kind of want to end, why do we do it? Why do we do estate planning? My dad began our holiday dinners with the following toast: an armored car never follows a hearse. My dad knew what to be true, that in the end, what matters most in our lives is not money, but it's family and friends, and ultimately love. Most folks have a misconception that estate planning is all about money and that we execute wills, trusts, to protect our assets and save on taxes. Well, that may be partially true. That's not the main reason people do it. The main reason is love. We love our children, our spouse, our siblings, our parents, our nieces and nephews, our friends. We want what is best for them while we are living on this earth and after. By having our affairs in order, we express our love to our loved ones even when they are gone. Specifically, we bestow upon them the gift of not having to make decisions when they are grieving for us and at their weariest. By declaring our intentions through our estate planning, our loved ones have the comfort of knowing that they are carrying out our wishes. And speaking from experience, it's much easier for a daughter to know that this is what dad wanted than decide that for herself. So before we get into the Q&A, I just kind of want to sort of say kind of what I do or what a typical estate planning lawyer do. I don't ever charge for introductory meetings, or a consultation, or you just want to hear a comforting voice because you're going through a rough time. So please always know that I'm here if you just need to have a conversation. Once I do meet and you decide you want me to help you with something, I always want to make sure that you don't ever receive a surprise. I clearly identify the scope of the engagement and the cost involved up front. I don't ever want you to receive a surprise in your billing statement. I also don't do cookie cutter documents. They are designed specifically for your situation. I provide English summaries in plain English of what the documents are. So you don't have to just read through legalese. You can just read through the plain English summary. And then we just, meet a few times, finalize the drafts. But so that's kind of how I do things. So I think at this point, I would just like to open it up to some Q&A and go back to wherever. Stop the share. Okay. So Princess, I'll let you, if we had any questions come through.
Yes. So one question was, what is probate and should I avoid it?
Okay. So the term probate means literally from Latin to prove the will. So if somebody dies with a will, we have to probate it in the county where the person died. So upon my dad's death, we took his will down to Cobb County Probate Court, and then the executor who was appointed in that will gets sworn in. In Georgia, probate is not a big deal. You're paying a few $100 to file the will, get the executor the authority documents the executor needs to do that. Other states have more expensive probate. So there's not really a reason to avoid it. But like I said, unless there's some situation where you have an heir problem, you want to cut out heirs, or we've seen clients who like, they didn't have kids, or their kid and had, their siblings are all dead, their siblings' kids, they can't find. I mean, it just is kind of a nightmare to go find the heirs. There's even like website services that track down heirs for people who can't find them. So in Georgia, I would advise having a will, because it's just really not expensive or time consuming.
Okay, another question was, a potential client might say that hiring estate professionals is expensive. Why would you not recommend that people prepare their own wills and figure out estate plans for themselves?
I'm not a big fan of LegalZoom. I mean, if you want to, or I don't want to say that, whatever, but I mean, this is a very complicated area. And I've seen some like pretty bad drafting of these documents. And a lot of times what you do in your will may not coordinate with, again, beneficiary designations or other things, or you may not be taking advantage of current laws. So yeah, I mean, if you want to try to give it a go, I mean, that's totally up to you. I mean, I obviously think it's better. You can find cost-effective legal services. I mean, I think the time involved and depending what your, time is with other things, doing that on your own, I don't know. I would like the comfort of knowing it was done right, but that's just me.
Okay, another question was, at what point do you think it's best for people to plan for personal tangible property, whether it's to be gifted or sold?
That's a good question. And I know who asked that, that question. Good question. A lot of times people, what I see, don't do it until they're looking at their will and they start thinking about their assets. We have clients, because a lot of times people change their mind of what they want to give, this painting behind me, or, my diamond ring. Like if I put that in my will, every time I change my mind, I've got to change my will. So we actually advise clients to sort of put that in a memo that's with their will. So the will actually directs the executor to sort of follow the terms of the memo, which may change over time. But whatever it is, it's important that you write it down. Like I don't like my executor decides who gets what. I mean, there's nothing worse than an executor having with a bunch of siblings walk through the parent's house and figure out, who gets what, or whether it's a lottery system, whether it's we draw straws. I mean, I was sitting there with my grandmother at her condo, and she's starting to say, well, you get this and you get that. And then she started just handing it to people, handed me a necklace. I was like, well, you get this. And I'm like, well, okay. But, she was like, I don't want, everybody figuring this out. I'm going to do it now. So I guess it depends on when you're ready. I mean, some people, aren't ready to give things up maybe, but now it's sort of the Marie Kondo mentality or the Swedish art of death cleaning. People are ready to get stuff out of their house. And I'm not sure, and I've asked my friend Kristen Vaughn, who's on this call, who at Hinman Auctions, whether, an estate sale gets more money or whether you can sell it more at your death. I mean, while you're living. So I think people a lot of times have a hard time, or I think their personal stuff is worth a lot more than it actually is, or it's more valuable to them than it is to other people. So again, personal stuff is hard. That's where people get upset. I'm like, who's going to get dad's watch, or who's going to get this? You see a lot of disputes. So I think it's good, whatever you're going to do, to make sure it is clear and not leave it into some poor executor's discretion to decide.
Okay. The pet trust is interesting. Should we talk to family members before we give them our dog or pet upon death? What if they say no? Can we do it anyway?
Typically what we say is, yes, ask them. Like my mom is giving her golden doodle, whose monthly grooming is more expensive than my own. She, I guess, conned my sister into taking over the dog if something happened to her, because I don't want to deal with the dog. So my sister agreed, and my mom was like, you'll get money for the grooming. But if my sister had said no, then you can tell your executor to basically find the dog a good home. And, whether it's your breeder or putting a notice, on Facebook, hey, this dog needs a good home. And, and obviously the executor has authority to, provide that person money who takes the dog.
Could estate planning attorneys protect a beneficiary if a personal representative fails to dispense the estate assets in the best interest of all the lawful beneficiaries?
Okay, so the estate planning attorney represents the executor of the estate. That's who the estate planning attorney, typically, if I was hired by an executor, I'm representing the executor, so doing with the estate. So a beneficiary thinks that an executor is not acting properly, the beneficiary would most likely, appeal to the executor. And there's things you can do. You can file certain things in probate court. You can file a petition for settlement of accounts where you ask the executor to basically kind of lay it on the table. Here's what all the assets are, all the debts. Here's how it needs to be distributed. And if the executor won't do it, court can force them to do it.
Okay. And do you recommend that personal representatives submit a bond?
In Georgia, typically those are waived. And most of our wills that we draft waive the requirement of a bond. And the probate forms, even if there wasn't a will, you can check a box asking the probate judge to, forego that requirement. I mean, typically it's not necessary unless it's usually a family member or somebody that's already involved in the administration of the estate. Again, if there's something where you thought somebody was on the up and up, as a beneficiary, you didn't approve the executor or thought they might do something, you could, again, petition the probate court to demand a surety bond. And a bond, for those who don't know, is sort of like putting up money to make sure that you do the right thing. I mean, so the money's set there to make sure it goes to the beneficiaries.
And those are all the questions so far.
Okay, great. Well, obviously, if anyone has any more questions you don't feel comfortable asking, again, my email is shanley@ldfirm.law. Princess, we're going to send out the questionnaire that was sort of part of this presentation to you. If you would like to kind of just, do it at your leisure, kind of get your affairs in order, you can have it. But again, if you have a personal question or something that you want to talk to me about, please feel free anytime. And again, I think we had what you wanted to take a little poll, Princess, at the end here.
Yep, we have a poll ready.
Okay, so we're going to do a little poll. I might play my little tunes kind of end the call, but again, yeah. So here's question 1. Do you have an estate plan? Oh, host and panelists can't vote. I can't vote. Okay. Okay, is that question?
Yep, it looks like 86% of the attendees do not have an estate plan currently.
Okay, all right. So you ladies need to call me. Get that. So I just want to, okay, go. There's another question. Sorry, I forgot. There's
You're fine. Question 2, have you had a life change in the last 5 years? Okay, it looks like a lot of people have had a life change and will probably need to add that to their estate plan.
Okay.
And then
was there one more question? Yeah, okay.
Do you feel prepared to take action with your estate planning?
Yes. You're basically telling me how I did today, so.
All right, it looks like everyone said yes.
Okay, awesome. Well, I cannot thank you enough for joining me. I hope you found it informative, educational. I hope you leave here feeling empowered, or at the very least, knowing you're not alone, whatever's going on with you. So I'm just going to close out with my little sort of favorite song with Annie Lennox or Aretha Franklin. Sisters are doing it for themselves. So you can stay on and jam if you want to, or just exit. But again, I'm here for you if you need it. So y'all have a great day. My song's gonna go or not. Well, my song doesn't want to start, but that's okay.
Stacey, looks like we had another question sent in about a minute ago.
Okay, yeah.
In regards to properties in multiple states, do you have to open an ancillary estate?
Yeah, if you own that property in your own name, you have to do what's ancillary probate. Typically, if this was property, I would advise you obviously to put that in some sort of LLC or put this property in revocable trust. But again, because yes, you would have to file ancillary probate proceedings in each of those states. And that basically is giving your executor the authority to sell that property or you transfer it. But if I had clients with properties in multiple states, I would advise them to put it in some sort of LLC. So the LLC would own it. So upon your death, the title does not change. Okay, my song is now playing. Okay, awesome. Well, everybody have a great day. And again, feel free to stay on the line or leave the meeting. So thank you so much.